Hello, everybody. Welcome to the Online Litigator, where our goal is to explore topics that help us do a better job of practicing law on Zoom. My guest today is Josh Sohn, who is a trial attorney at the U.S. Department of Justice. He is a former of counsel at Quinn Emanuel and a graduate of Harvard Law School. Josh recently wrote an article for Law 360 titled Remote Hearings Should Be the Default in Civil Litigation. And I am thrilled to have him here to discuss this topic. Josh, thank you for joining us today.
Thank you for having me.
Your article mentioned spirited and hard fought motions that have been conducted remotely during the past 2 years. Let's start by let me asking you, how have your online litigations differed in intensity from their in-person antecedents?
Sure. So at the outset, I am obliged to say I'm speaking in my personal capacity and not as a spokesperson for the DOJ. They require me to say that. But that being said, I have litigated many online hearings for the DOJ in the past 2 years. And in terms of intensity and preparation, I really find there to be no difference. Before both in-person and remote hearings, I do the same prep, create the same outlines, create the same binders of key cases, do the same mock arguments before DOJ lawyers, and be prepared to answer adversarial questions from an Article 3 federal judge. So I find that there is really no difference in either the intensity or the preparation. The only difference is that you're doing it all in a courtroom versus over a video conference screen.
One of the things I was so impressed by about your article was how well researched it was. So, can you do me a favor and tell me what the legal authority says about remote court proceedings?
Sure. So there's very little legal authority on remote court proceedings per se. Certainly, there have been any number of minute orders issued by district courts over the past 2 years, or even before. It's not like remote hearings were unheard of before the pandemic. But as far as sort of what you would call black letter law, there's not much on remote hearings per se. But what there is, as I mentioned in my article, is there's Rule 78 of the Federal Rules of Civil Procedure, which make it clear that courts can adjudicate motions with or without hearing, which implies the corollary power to decide what type of hearing is most appropriate. That seems pretty clear. And then there's the overarching rule that most civil litigators skip over. They think of it as sort of throat clearing, just prefatory fluff, but that's Federal Rule of Civil Procedure 1, which says that all the federal rules, so including, of course, Rule 78, should be construed and administered to secure the just, speedy, and inexpensive determination of every action. And if that's not clear enough, the advisory committee note to Rule 1, which I cite in my paper, actually sharpens that even a little bit more. It says that courts have an affirmative duty to ensure that civil litigation is conducted without, quote, undue cost. So that is sort of a global omnibus command that federal judges really are supposed to heed in how they conduct all of their business, whether it be hearings or any other aspect of civil litigation. It's supposed to be done in an inexpensive manner. They really have an affirmative duty to try and eliminate any costs that they find undue.
And that mandate to eliminate unjustifiable expenses, it's really the linchpin of your argument in favor of remote proceedings. Uh, I guess the question that I have to push back on that, is there a case to be made that in-person proceedings are a justifiable expense?
So, as I discussed in my article, there certainly are some circumstances where they would be. I raised the issue of evidentiary hearings, where you have witnesses taking the stand. And where you have judges judging the credibility of those witnesses. I think there's plenty of statements in the literature that this sort of credibility judging and the direct and cross-examination of witnesses on a witness stand is better done in person. And I'm not 100% sure that's true, but frankly, that's not a hill I'm willing to die on. I think it would be a real change, a step into the, not exactly the unknown, but a step into the uncomfortable if evidentiary hearings were done online. And so I'm sort of prepared to concede that, post-pandemic, those should all go back to in-person. And as I also stated in my article, there could be other sort of edge cases where a civil motion is best done in person. I mentioned in some federal patent cases, particularly in the mechanical engineering arts, you could have motions where the lawyers literally truck in 3D exhibits of the accused product and kind of have a pointer to point out different parts of this machine. And that's something that certainly is best viewed in person rather than over a video screen. But what I was focusing on is not the edge cases of evidentiary hearings or hearings with 3D demonstrative exhibits, but sort of the base case where a hearing is effectively lawyers armed with nothing more than papers in front of them, arguing points of law and record citations to a judge and fielding questions. And that sort of thing, I believe, can be done equally well over a video conference screen. That Q&A, I don't think you need the expense of lawyers, potentially traveling hundreds of thousands of miles and renting hotel rooms. So for that base case, I would argue that the extra travel expenses of in-person hearings, by and large, are undue. And that's why I reached my conclusion that the default really should be remote hearings.
Your article seems to exclude scenarios where both lawyers are arguing a civil motion locally. You talk a lot about airplanes, and you kind of even carve that out, that most motions involve a lawyer getting on a plane. How does your conclusion with respect to remote proceedings hold up for the vast majority of civil litigation cases that do not involve air travel?
I would push back on the premise that in federal civil litigation, the vast majority of hearings involve two local lawyers. Certainly, individual experiences may vary, but I've argued scores of hearings in federal court. And sitting here today, I cannot recall a single hearing I participated in where both lawyers were local. That may be a function of the types of cases I've litigated. When I was in private practice, I generally litigated large intellectual property cases and large complex commercial cases. Now at the DOJ, I largely litigate very large civil forfeiture cases arising out of cases of grand international corruption. So certainly my data set could be skewed. But in my experience, it's actually rare for both arguing lawyers to be based in the same city as the court. Now, that being said, obviously such cases do exist. And if there's one touchstone in my article, it's that judges should have the flexibility to do what makes sense in an individual case. So if a judge is looking at the docket sheet, looking at the counsel appearances, realize she's dealing with two local firms, then certainly that would be a circumstance where there's really few, if any, cost savings to a remote hearing. So I guess to sum up, I think more hearings involve travel than perhaps your question implies, but I certainly would agree that in cases where there is no travel, the case for remote hearings becomes much weaker.
You added an important qualification there, and maybe this is inherent in your article, and I'm just reading it from my point of view rather than your point of view. But that qualifier obviously is federal cases.
Yes,
and I think that perhaps the disconnect between the question and your position takes into account that maybe those cases that I'm speaking of where both lawyers are local, maybe those are more state court cases.
Yeah, that's possible. And remember that the main authority for my position is Federal Rule of Civil Procedure 1.
Right.
So my article was quite explicitly pegged to federal civil proceedings.
Although one would assume that there is some state court parallel to Federal Rule of Civil Procedure 1 in every local jurisdiction. And if there's not an explicit rule, that an efficient court system inherently requires the inexpensive dispute resolution, right?
Yeah, so the vast majority of my practice is federal, so I don't have a huge amount of experience with state civil rules. That being said, I do know, I was speaking with a very smart lawyer, Rafi Melkonian in Texas, and he informed me that the Texas state rules of civil procedure have an analog to Federal Rule 1. And it would not surprise me, as you say, if many other state court systems have similar rules.
So your article acknowledged that some judges may conclude that the grandeur of an in-person hearing improves quality of advocacy. I guess the point of the question I want to ask you is that your conclusion that remote hearings should be default certainly doesn't seem like it is the way the wind is blowing. I mean, it certainly doesn't seem like that's where most practitioners or judges think we're going to land. And I guess my question is, are we really just arguing about formality and tradition? Is that really what's happening here?
So as a preliminary matter, I think it's a little bit of an open question how we're going to land. We're just moving back to, we're getting over an unprecedented experiment with the pandemic. So I think it's a little bit of a jump ball what things are going to be going forward. And that's why I thought this was an opportune time to write my article, because judges are now deciding, okay, the pandemic appears to be, if not waning, about to wane, and we need to decide what the new normal is going forward. I think certainly, we've talked a lot about defaults in this interview. Human nature is to default to what you've done before. So I think it would be likely, though, in my opinion, unfortunate, if we did go back to the same default we had before, which is where most hearings were presumptively in person, because I think that does not actually advance the cause of justice, again, in the basic case scenario of lawyers just arguing to judges. And I do think the practice we've become accustomed to of in-person hearings is mostly about tradition. Obviously, for the first 200 odd years of American jurisprudence, there was no really good alternative. And since the dawn of modern communications, I think people have just sort of done it the way we've always done it. And that's not to short sell the fact that there really is some theatrical grandeur about the thing. The judge striding into the courtroom and the all rise. And if it's a big motion or if there are a lot of other lawyers waiting on deck, you could have a packed gallery. I mean, there's some excitement and charge to that. I'm not going to dispute that. But I don't think the theatricality of it is enough to override the Rule 1 mandate of, you should be eliminating costs whenever the pursuit of justice wouldn't be harmed. The pursuit of justice is the most important thing, but all else being equal, if you can equally adjudicate, if you can equally do justice through option A or option B, if option B is less cost, you should do option B.
Now, I know that there was an article written in response to your article. Do you have any thoughts about the rebuttal article that was published by Law 360?
Yeah, so the rebuttal article was well written, and I certainly appreciate the time and energy it took the author to engage with my article. And I thought his basic conclusion, actually made a lot of sense. His bottom line conclusion was, why don't we have it where judges set up procedures where lawyers can either participate in person or do it remotely? And I think that makes sense with one important qualifier. So the reason it makes sense, of course, is that, look, if a lawyer and her client want to spend the extra money to travel across the country to a hearing, I don't see any, really pressing reason to forbid that. So on the surface, I think kind of opening it up to either in-person or remote participation makes a lot of sense. The qualifier is this: lawyers are very risk averse. Lawyers, obviously, litigators, want to curry favor, for lack of a better phrase, with the judge there before. So I think if a judge is going to open it up to either remote or in-person hearings, they should make it excruciatingly clear that lawyers will not be penalized for either option, that a lawyer who chooses to participate remotely, the judge is not going to infer that that lawyer is less engaged or treats it less seriously or treats it less important. Because I think without such clear language, the natural tendency of a lawyer is to think, ooh, I don't want to take the risk that doing it remotely is going to cause the judge to think I'm mailing it in or cause the judge to think I'm not as invested. But I think if judges are, again, sort of excruciatingly clear that they're not going to hold it against the lawyers for picking either option, then I think sort of putting that option before the lawyers makes sense. I think the only other thing I would push back gently and respectfully on the rebuttal article is the article talked about how in-person hearings give a level of experience and opportunity to junior lawyers that remote hearings might not. I don't think that's true. It's certainly true that oral argument is a learned skill and you have to do it to get it, and you improve with each iteration. However, I think the skill you're learning is the skill to stand up in front of a judge, appear, I shouldn't say stand up, should I? I should say appear before a judge, and cogently argue your points under pressure and field adversarial questions under pressure. I think that's the skill that you learn by doing, but I think that skill can be equally done whether the judge is putting you through to your paces and asking you questions over a video screen or in person. So I would resist and I guess gently disagree with the argument that somehow it's better experience to do it remotely. And in fact, my final point, it's actually quite possible that remote hearings would give more opportunities to junior lawyers. And that's because this. Often, particularly in large cases, near the end of discovery or shortly before trial, you sort of have omnibus hearings where you might have all the summary judgment motions, all the Daubert motions, perhaps a late-breaking discovery motion or motion to strike, and they're all consolidated at a given hearing. And when the hearings are in person, obviously the senior partner or the partner in charge of the case is probably going to be arguing the most important motions. And if it comes to the question of, flying lawyers all across the country, the partner might then decide, well, I'm just going to argue all of them because it doesn't pay to take an associate with me if, the majority of the really important motions I'm going to be handling anyway. But if hearings are remote and there effectively is no cost, well, then I think partners might be more open to saying, yeah, this one motion, which maybe isn't as crucial or is really a long shot, we're not expecting to win it anyway, I'll throw that one to a junior associate. So I actually think it really is possible that if hearings are remote, reducing the friction of travel costs at the margin would cause partners to throw more motions, over to more junior associates, precisely because I don't have to drag them across the country.
Yeah, there's a little bit of a circular nature to the argument, isn't there? That you have to have in-person hearings so that you get junior associates experience at arguing in-person hearings.
Right.
When in reality, if we were moving all towards remote, then you would say to those junior associates, well, the experience that you're getting is arguing remote motions, right?
Right.
It's kind of like, I push back a lot. The other thing that I think fits into this conversation very closely is Zoom School. That, like you said, it was a grand experiment. Everybody tried Zoom School. I get the sense from talking to people that very few people really liked Zoom School. But one of the things I keep saying to people is my job is right now 100% remote. Josh is practicing law down in his basement, or I'm sorry, at your house, wherever you're doing this. It seems like it's a mistake to be trying to train children for an in-person experience when at least some portion of the jobs that they may be getting are remote jobs. And I think the same thing is true with junior lawyers. It seems a mistake to try to train them for only in-person advocacy when the reality is that some of the advocacy that they will be doing in the next 20 to 30 years over their career will be remote.
Right, and that's a great point.
Okay, so my last question for you here. You've obviously done a ton of remote litigation over the course of the last 2 years. If you had the ear of the research and development arm at Zoom, and you could make just one change to Zoom to make it more litigation friendly, what change would you suggest to the developers at Zoom?
I'm not sure I could make a change to Zoom per se. I think most of the glitches I've seen, and glitches is even maybe a little bit pejorative, but you do see occasional data lags where lawyers' faces jump around a little bit on the screen, get a little pixelated. But I don't think that's the fault of Zoom. That's sort of the fault of the ISP provider and the bandwidth issues. So I think I would repackage your question a little bit, and I would say to law firms, make sure you have really good bandwidth. And as we move more towards 5G nationwide, I think this should maybe solve itself. But obviously, remote visual hearings do take a lot of bandwidth, and you have to make sure that the data throughput works. But again, I actually don't think that's an advice to Zoom. That's an advice to the whatever the hardware and fiber optics companies that deal with transmitting large amounts of internet data. So the advice I would have to them is make sure the throughput is enough so you sort of have a seamless visual experience.
Well, that's great advice. All right, the article is Remote Hearings Should Be the Default in Civil Litigation. Josh Sohn, thank you so much for your time and for your thoughts.
Yes, thank you for having me. I really appreciate it.